This program is brought to you by Emory University.
Okay, by this time you should have your program evaluation, so make sure that you complete those and return them to Michelle or Melinda at the registration table before you leave today. That's how you'll get your parking validation. I also want to thank the participants on live stream for joining us, and I sent you the link to Judge Rawlings' PowerPoint, which is also available on the Barton Center's website, so you can follow along with us from your jurisdiction. I do want to remind everyone that the next Child Welfare Legal Academy will be May 20th at 12:15. This will be a little bit different because we'll be doing it at DeKalb Juvenile Court. And you can go on to bartoncenter.net to find the details about that. But it's going to be a really engaging discussion about helping older youth, so I'm really excited about that. And so now I'll turn it back to Judge Rawlings. Thank you so much.
Thanks. All right, welcome back. So I said that when we left earlier, I said we're going to look at the four-factor test. So again, the child's dependent, the parents that cause the deprivation is likely to continue, and it will cause the child harm. I think this is probably an accurate statement of the current state of the way the Court of Appeals looks at these cases. It is well settled that compelling facts are required to terminate parental rights. But I don't think that's, I think this is a philosophy that is kind of ascendant. I don't know that it's been something that the Court of Appeals has always looked at every element, at all of the facts, and I kind of want to show you a few things that I hope support my theory here. If you look at the published decisions, and I found out a minute ago, we're going to talk about this a little bit in the question and answer period, my assumption had been that if the cases were reversed, they'd be published, but I found out she's got an unpublished reversal in one of hers back there, so we're going to talk about that in a few moments too. But if you look at the published discretionary appeals that were granted and then published from 2010 to 2012 in the Court of Appeals, 19 were affirmed, 2 reversed, and only 1 vacated for more findings. Between 2013 and now, of the published opinions, 15 of them, 10 have been reversed. So what's going on here? Okay. There are really several things that I've noticed in the published opinions. Number one, and let me step back for a moment to say, should not be considered, going over these should not be considered an academic exercise. The question is not, well, what is the Court of Appeals doing? The question is this. The question you should ask yourselves, whether you're a lawyer or a judge, is this. If I'm a judge, what can I do to make sure that my opinion is better understood by a reviewing body, and that I have incorporated everything I need to do to justify my outcome that I believe is the correct outcome? If you're a lawyer, and I think whether you're a lawyer for the parent, the child, or the state on these cases, I think we all have an obligation to make sure that these orders and the records are complete. Because especially we're not fighting over money in these cases, we're fighting over the future of a child. And I think we all have, we may have different sides on it, but we do all have an obligation to make sure that the record is absolutely full and is absolutely representative of the child's actual situation. But with that in mind, there are a number of reversals where there was simply a lack of finding on what the court considered to be specific required factors. Now, I would say that nowadays the court's requiring findings on all 4 factors, especially the likelihood that dependency will continue and the likelihood that the child will suffer harm if there's no no termination. I think Judge Dillard has often chimed in concurrence on a lot of these cases, and quite frankly, I think his concurrences are quite interesting. He said in one, in the interest of AES, I find it troubling that many of our prior decisions upholding the termination of parental rights appear to rely on generalizations without specifically tying them to particularized findings of fact. And going back to the factors, let me say this. I remember back in the early 2000s when I was a fairly young, a lot younger than now, judge, and I would occasionally do for somebody or another a summary of recent Court of Appeals cases. And you could find in those cases, one day they would say something to the effect of, we agree with the juvenile court's findings that are entitled to deference. The child is deprived because the parents did X, Y, and Z or didn't do X, Y, and Z. And the parents haven't completed their case plan, so therefore the deprivation is likely to continue. And the same facts that showed the deprivation is likely to continue show that the child will be harmed. Okay? Now you can almost Google that phrase or whatever the equivalent is in Westlaw and come up with a dozen cases that say that. Okay? But the current Court of Appeals, I believe, is much more likely to say the exact opposite, which is it may be true that the same facts showing that deprivation exists and that it's going to continue will harm the child, but prove it to me. Tell me what facts you accumulated at your TPR hearing, what expert testimony showing that this child is going to be harmed by a relationship with his parent. I think a good example of this is the following, I'm not going to quote the case specifically. I think I may have cited to this one in my paper, but this is the basic philosophy, I think. The court seems to increasingly be of the opinion that the mere fact that you cannot be a good parent doesn't necessarily equate to the solution being to sever your relationship with your child or the child's relationship with you. Okay? And if you think about it, that's really where the harm element comes in. So think about that. And if you're writing orders for a judge, if you're a judge writing his or her own orders, make sure that you're covering each of those 4 elements very clearly, please. The other thing I found in a number of the cases reviewed was, and it's got to be, now think about it, okay, you're a judge sitting on the bench, or how many of you, a lot of times I know SAGs will write the order for the judge in a TPR case, which is perfectly fine. And I've read so many TPR orders in the last couple of years that are like 20 pages long and 16,000 paragraphs, and quite frankly, I think it probably took longer to write the order than it did to try the case sometimes. That being the coming from the fact that we know kind of instinctively now that the Court of Appeals wants specific findings, right? So we have these orders that are very long, very involved, very specific. But sometimes I think that what happens in the middle of writing these long orders is that either the judge or the attorney writing for the judge says, yeah, and so and so and so happened. And it's not in the transcript, folks. And the Court of Appeals these days, in the cases I've read, will call you out on that. And it's got to be a little embarrassing. I mean, if there's one thing that, I've been reversed when I was on the bench, and nobody likes to be reversed because I'm the best damn judge there is. So everybody thinks. But the truth of the matter is being called out for being wrong, for the Court of Appeals says not only is your legal analysis wrong, but you can't even get the facts right. It's got to be a bit embarrassing. But I don't think it's necessarily that the court, says made up something. What happens is this. We know that these cases are very fact intensive. They are often, as I said, carried out not simply in, 1 day or a 2-day trial, but maybe over 3 or 4 different sessions. You take notes on it, but you don't have the transcript ready when you're writing the order. And I mean, think about how these transcripts are expensive. Somebody's got to, either got to listen to the tape or you got to, have somebody print the whole thing out, and that costs a lot of money. So, I think all of us in court need to feel free when we see an order that a judge has written that simply misstates what happened. I'd rather be called out by an attorney if I were a judge than by the Court of Appeals. So I don't think there's any problem with calling folks out on things if they just get it wrong. Because the bigger issue for the Court of Appeals is probably this. They probably feel that if the court is citing something as the basis for its decision that doesn't appear in the transcript, then they must have really missed a lot of things here. So they're going to pay even more attention to that case. I think we do need to think about, in the future, we'll come back to this in a moment, about maybe how we can get these transcripts so we can write orders based on them, or at least, find some way to make sure that the transcript matches the order before the case goes up on appeal. And we'll come back to that as well. And as I said, I think there are some serious judicial concerns over the significance of these cases. Okay, we all know that TPR is the parental death penalty. I think that if you look at our child welfare system in general, we all know that we have gone through periods of time in which the focus was on children in foster care. Okay, their rights, their needs. We've also gone through other phases in which there was perhaps a greater focus on the rights of families to stay together. We know that we all have sort of this pendulum of what we're focusing on today. Keeping family preservation versus foster care, rights of parents versus rights of children, safety versus family togetherness. And I think that our courts probably go through the same sort of change from time to time when certain things will come up that lead the judges to say, maybe it's time we focus a little bit more on this particular aspect of our jurisprudence. And my review of the cases indicate that that the court is focusing on a couple of things these days. Number one, that the court is imposing a death penalty of sorts on a family. They're taking that family and splitting it up forever. And so, therefore, to make that decision requires more than simply the finding that a parent is not a good parent or has not completed a case plan. You've got to find that the parent and the child are in such dire straits that either there's not a good parental bond or that things are so bad that that bond needs to be severed so that both can go their separate ways. But if you look at these things, I think what it says to us as the practitioners is that when we're trying these cases, we've got to make sure that we focus more on demonstrating not simply bad parenting, but the impact that that bad parenting has on the life of the child. And I don't mean, of course, in the usual, as Judge Dillard said, generalities of we all want permanence for children. Because tomorrow, the societal focus may be on safety for children. See what I'm saying? And I guess in terms of what's required for us these days based on the four-factor test is the following. Proof of every factor by clear and convincing evidence. Not enough to show parental incapacity, as I said. You've also got to show how that deficit affects the child. To give you an example, I have a fishing buddy who's, some of y'all know, whose mother had this fairly severe mental illness, and as he says, he turned out fine. I think that the court, I've seen a couple of cases lately where the court was dealing with parents who had some physical or mental illness that prohibited them from effectively parenting. But the court seemed to react somewhat in horror that the state would try to sever that parent-child relationship merely because of the parent's incapacity. So when we're dealing with those cases, we've got to make sure that we're essentially not discriminating against people on the basis of a disability. Does that make sense? On the same same lines, I guess, if the juvenile court's opinion appears to be discriminating against a parent on the basis of poverty, I think you can expect a reversal in a lot of cases. Why? There are a number of statements out there recently especially where you'd have a case plan that required the mother, for example, to get a GED, to obtain and maintain stable employment, and to obtain and maintain stable housing. And, for example, in one of the cases I reviewed, the court said, well, she was living out in the middle of nowhere in the middle of a bad economy, and yet they're terminating her parental rights. They used her inability to get a job as part of the main reason for terminating her parental rights. That, to us, smacks of discriminating against her on the basis of her poverty. Okay? So, going back for a moment, that kind of tells us the following. When we're constructing the case plan even, okay? If you got a parent who can't support his or her child and needs to get a job and needs to have stable housing, but for whatever reason has had trouble doing that, if it's because of drugs, then focus on the drugs. If it's because of just not caring, then focus on the not caring. But I think too often what happens is we go down the road through the permanency planning process, through the deprivation hearings and the court process, and then when it finally gets to the TPR, we look at the law and the law says the court may find parental incapacity if it finds that the parent didn't follow a case plan for more than a year. And look, Judge, she still doesn't have a job. Well, that's not really the issue, right? The issue is, Judge, she doesn't have a job because she hasn't looked for a job and she's still on methamphetamine, right? And so what I'm saying is this. I think we have too often tried to take some shortcuts to TPR that I'm not sure this current court is going to smile too much on, okay? So, again, we know, we have all these blanket statements of the law from the past, and while they may still be good law, what we've got to do is focus on what this court wants. And what this court wants is specific proof that the child is not receiving proper parental care, that there's something indicating that that really is going to continue, and especially if it's parental fault, although they say, parental fault doesn't matter, and specific proof that the child's going to be harmed, such as a discussion perhaps from an expert on how lingering in foster care hurts children, and how the child is beginning to develop some sort of attachment issues because mama keeps saying we're going to get back together soon, and it's not going to happen. Okay. But here's what I think, and this is what, again, I told you this conversation started off as a judge saying what's going on with the Court of Appeals, and I think in sum I have to say the following: the court's not doing anything it hasn't been doing for the last 20 years. We're getting the same statements of law. We're getting the same difficult facts. But I think the difference is this: because these cases are no longer handled by direct appeal, because they're handled by an application, then there's the sense that if one of these cases gets an application granted, which we've already decided maybe for good reasons or maybe not, depending on the responses and the material filed at the time of the application, if the court gets the application and grants it, then they say, this case must be more complicated than it. Let me dig into it. Let me dig into this case. This is not routine. I've got to figure out what's going on with this. The central staff folks and the judges who looked at this case in terms of granting the application saw something in it, and so therefore I'm going to pay a lot extra attention to it. And I think that's where we are. So, what do we do about it? There are a few, I think, improvements we need to deal with. Because what we want, again, what we all want, whether we're judges or Court of Appeals judges or juvenile court judges or attorneys, what we all want is a system that works smoothly, that creates a solid record, that contains work that we can be proud of, and that in the end speaks the truth regarding a family situation. Whether that truth is that this parent needs more time, this parent needs more help, this child needs permanency, or what may be the case. So I think the first thing we have to do is deal with the transcript issue. How do we make sure that when we're filing an application, that the application actually reflects the case, and especially how do we avoid the problem of dismissed appeals? I've seen a couple of cases that have been published. One of them is AMB, the other is MMMT. They're both cited in your paper, in which the court read the application, saw something in it that made the court believe there was error in the trial court's judgment, granted the application, brought it up, and then, lo and behold, it read the transcript, and as I think Judge McFadden, if I recall correctly, said in his special concurrence, they dismissed the appeals as improvidently granted, and Judge McFadden said, well, once we read the transcript, we found out that it really didn't match the application. Okay? Now, whether that's true or not, who knows? I mean, I'm sure that whatever attorney did that felt solidly that they were presenting a good, solid case to the court. But the problem is that there was a miscommunication somewhere between that attorney's mind and the Court of Appeals mind. So one thing I have seen done, I did a little informal survey with some folks and got back a few responses for recommendations. Some folks are doing a motion for new trial in these cases so that they can await the transcript. That's good perhaps when, especially if you can, especially in indigent defense cases where you can go ahead and get the transcript for free, and especially if you can get the transcript in a timely fashion. But as we know, in some areas, there may be 3 court reporters involved in a 4-day hearing, and it just takes forever to get a transcript out of anybody. And in fact, there have been a couple of cases, there's one in Gwinnett County, for example, from about a few years ago, where the case, the TPR, I believe, if I recall correctly, was filed in 2006. The hearing, or the case came down in 2008, TPR ruling, and it was finally 2 years later, no transcript had been done, and the trial court dismissed the appeal, and then that was appealed, and the Court of Appeals affirmed the dismissal for failure to timely get the transcript. So in other words, there were like 4 or 5 years there where the child was just sitting there in limbo, right? But again, if, for example, if in your jurisdiction you can get the trial transcript within, say, 60 days, then I think it would probably be a good idea in cases in which the family or the parent or whatnot wants to appeal, to get the juvenile court judge to say, okay, file a new motion for new trial. That delays the time for filing the application. We'll get the transcript, and then as soon as we get the transcript in, I'll deny the motion for new trial, and you can take the matter up. And that worked. That has worked for some attorneys. Another possibility is, and I can't remember I don't have the site for the code is in your paper. I can't remember it off the top of my head. But I know we're all litigious people, but do you know that you can agree to a transcript? Who has ever read transcripts from like 1910? My granddaddy was a Superior Court judge back in the like 1910s. Okay, long story, but big generation gap in my family. And we used to have some papers laying around, and I'd look at the transcripts that were laying around, and it was like the court reporter just basically typed up not a verbatim transcript, but just kind of a summary of what happened. And that was the transcript. That's what it went up to the appellate court. And I think that we could do the same thing. The law allows the parties to get together and agree on interesting or important facts. Okay? So you could, the state and the child's attorney and the parent's attorney could get together and say, you know, the parent's attorney says, I want to appeal this issue. Can we agree that these are the facts? And we'll write those down and sign off on it, and that will be, at least for our application, what we've agreed to. I think another thing we need to consider doing is speeding up the time to prepare the transcript. In your paper, you'll see that in Florida, they have now come up with, in children's cases, a children's fast track, I think they call it, where the transcript has to be done in 20 days. And in fact, they serve notice on the court reporter that we're filing an appeal, and you better have that thing in 20 days or else. You know, we have a rule here that says you got to have the transcript in 30, but how many of you ever have a transcript in 30 days? It just doesn't happen usually. And I think another thing to consider doing is if we could build in a practice where the court could itself review the transcript, if we could get it more quickly, and make it corrections and additions to the order. So to give you an example how that somewhat could work now, under, I believe it's in the paper, I believe it's 9/11/52, if I recall correctly. 9/11/52 allows parties to file a motion with the Superior Court usually, saying to either correct or expand findings of fact. And that motion can be filed within 20 days of the judgment complained of. And that gives the court an opportunity to fix stuff that maybe people are misremembering. And of course, if you could get a transcript in that time period, then you could do it a whole lot more simply. So the point being this: if we want what we really want, yeah, do we all want to win? Sure. But what we all really want, I think, is for a ruling to be correct so that the parties can move on with their lives and the right things can be done. And if we can take these steps so that the court is on the same page with the parties before anything goes up on appeal, then we're a lot better off. I'm sorry, here it is, 9/11/52. Upon motion made not later than 20 days after the entry of judgment, the court may make or amend its findings or make additional findings and amend the judgment. Another thing we ought to consider is whether or not we need to really expedite these appeals. Again, Florida, pursuant to their rules adopted in 2009, once they have an appeal in a children's case, when it goes up and it's all briefed, the court has to rule within 60 days. Now, do they ever do that? I don't know. But I know what the rule is. And I know that, I don't think we should complain too much about our Court of Appeals. I think given the fact that it's one of the busiest courts in the country, that they do a really good job within the 2-term limit, okay? So we're getting our cases back within a year. But if you look at, for example, the Parental Notification Act, 1511-684, I believe it is, talk about an expedited appeal process. There was a case came out, Judge Ellington decided to, I don't know, this was last year I think it was, parental notification of abortion. The juvenile court did not, refused to waive the notification requirement. The child took it up on appeal. And you know how long it took the Court of Appeals to decide that case? From the time the juvenile court made its decision to the Court of Appeals decision was 11 days. Now, can you prepare a transcript in a TPR hearing? And of course not. But one of the things that concerns me is that the only real expedition of these cases, so to speak, right now, is by the internal rules of the Court of Appeals. And that goes back a long time. I remember when I was a clerk there, you'd have a TPR case and it would be stamped expedited appeals pursuant to internal court rules. But if we had a statute, perhaps we could speed it up even further. And perhaps the court could look at doing what they've done in Florida, for example, to really make these cases turn around quickly. And again, I hate to keep repeating myself, but why? Because I can't stand the idea of a child whose the juvenile court has decided that the parents can't parent anymore, who's sitting there in foster care for a year or two sometimes, not knowing what's going to happen. And we all know that sometimes in that limbo time, one DFACS might decide everything's fine, and then suddenly they get reversed and you have to start all over. Just by the way, I think we're doing fine because the National Council of Juvenile and Family Court Judges and the ABA all say that 215 to 240 days from TPR to an appellate decision is appropriate. I don't think so. I think that's too much time. That's just me. Now you can all throw rotten fruit at me because I apparently have complicated the issue recently. Who has read the BRF case? Okay. If you have not read that, I recommend it to you. It just came out came out March 30th. There was a motion for reconsideration. Came out April 14th, 2015. Tell you the facts. A family walked in my office, 2 years ago now. And it was a young woman who, it was apparent had some mental limitations. She was, and her father, who was apparent was, I mean, the record didn't, he seemed nice to me, but the record said he was a really difficult fellow. And so they were concerned because she had had a baby while she was still a minor and living with him, and they had gone through a TPR trial, and she had had a court-appointed attorney, and the judge terminated her parental rights. And then her court-appointed attorney said, my contract doesn't cover appeals. So he told her she was kind of on her own. And she, again, she was indigent, of course. She was 18 or 19 at that time. She filed a notice of appeal, and then the juvenile court later said, well, that's not the right procedure. You had to file a discretionary application, so it's dismissed. So almost 9 months, I believe, after that was dismissed, after the TPR, she came to my office, and we filed a motion, a application for out-of-time appeal. And under the SMB case, which had gone previously, the court said that the juvenile court couldn't grant an out-of-time appeal in a discretionary TPR application, but that maybe the appellate courts could. And so earlier this month, or really the end of last month, the Court of Appeals found that because Georgia has set up a statutory system giving indigent parents the right to an attorney at all stages of the process, including the appellate process, and because this application is the only appellate process, that the attorney, or at least an attorney, is required to assist the parent throughout that process. And so the court found that she was, in fact, entitled to an out-of-time appeal. Now, they ended up affirming on the merits, which is the way it is, but what that has done is the following. It means that all of us who represent parents in cases are now even greater in a kind of a bind. Because if we have a contested TPR, then, and we feel personally that an application for appeal is meritless, then do we have to file the application anyway? See what I'm saying? Are we going to get in trouble if we don't file an application? I think that there are some ways around this issue, and here's what I want to suggest to you. In Florida, let's see if I got it here. Nope. Florida, and you'll look at, there's a case in Florida that came down, and it's very similar to a process. How many of y'all practice in the Southern District of Georgia at all? In the Southern District, I do a lot of criminal appointed defense down there. And one of the things that always happens is, our clients will plead guilty, and then, of course, after they're sentenced, they want to appeal anyway, even though they have filed a limited waiver of appeal. And so to kind of cut off some of these issues, the court requires that when after the sentencing, that we sign a document indicating that we have consulted with the client, and the client has to sign as well, and the client either wants to appeal, and we agree with them, or the client wants to appeal and we feel that would be frivolous and completely meritless. And if it's meritless, then we can do a motion to withdraw an Anders brief, which some of y'all may be familiar with, and that kind of thing. But I do think that given that there is the possibility now of an out-of-time appeal for parents who have been denied appellate counsel in indigent cases, that we're going to have to develop some kind of procedure so that parent attorneys can assure the court and show to the court that they have consulted with their client on this issue and either have filed an application or have told the client that that's not sufficient, and maybe even the court can appoint somebody else to do it. I'm just not sure what to do with this, because the worst thing in the world we want, and I'll say this, I think my client deserved an out-of-time appeal in this case. I'm glad she got it. But at the same time, I don't want to see every single case turn into an out-of-time appeal 9 months after the fact. That would not be good for our system. So, if you have any questions about that case, or about if any suggestions about how to deal with this, with that matter going forward, about what we should do as the bar, please let me know. And I think the final thing is this. Again, I'll go back to what the judge said to me. What on earth is going on with the Court of Appeals? Based, of course, on the fact that so many of the cases he or she had seen involved reversals in the last couple of years. We have got to do something so that we as the bar can better understand the Court of Appeals work in these cases. And we currently don't know what is happening with all the applications that are filed, because the applications, when they're denied, it's just a simple order, denied. Because they're confidential, we can't go and read all those applications. But we need some process by which we can become better educated about what the Court of Appeals likes to see in an application for appeal, and also, of course, by the same token, what the Court of Appeals expects us to be doing at the trial or hearing level. And so my suggestion is this. The Attorney General's office, when we started off this thing, the Attorney General's office was not comfortable with us going in and reviewing all of those applications. And so why not? Well, we said, well, look at OCA sections 1511-700, which says the court may allow individuals into court when it's an otherwise closed case who have an appropriate interest in the work of the court. Okay? And 1511-704 similarly says the juvenile court can allow representatives of recognized organizations to come in and review the records of the court, to gather statistics and figure out what's happening with kids and that kind of thing. Unfortunately, at this point, there's no clear law that says, and that applies to the appellate courts as well. So all of those of you who do policy work at the legislature, what I'd like to see next year is a law that allows the Court of Appeals to allow someone like Araceli or somebody to come in and review those records so that we can develop an ongoing curriculum and sort of an information database about what's happening with appeals, how we better handle them, recommendations for improvement, and that sort of thing. Now, that, in a nutshell, is my entire presentation. But I want to call on a couple of people because they have interesting points. So would you come up and tell me what happened with your...
Me? Shall I just go from here? I had a 2014...
Come on up here, because we're gonna put you on YouTube.
Yeah.
Yeah, I had a 2014 case where I served as a guardian that was appealed. It was reversed. The only one of the factors that was considered was whether the dependency was likely to continue. When they read the very last paragraph of that, and it was unpublished, the last paragraph of that unpublished opinion basically said, but this doesn't mean you need to return the kids right away. You need to check and see how the parents are doing. We found that the parents still had the same issues that the dependency was based on. So we just finished a second TPR on that,
Right.
on those parents.
And I think my concern is that, that kind of throws our numbers off. We don't, if they're, we generally assume that, or presume that if something's going to be reversed in a case like this, they do a published opinion. But if they're doing unpublished reversals, that makes us wonder even more, how do we know what the court wants if they're not telling the bar, what's going on? So thank you. Anybody else?
I've got questions.
Yeah, can you, and just say it real loud and I'll repeat it.
Not a problem. I'm presuming that we're talking about deprived and neglected children that have either their parents are in drug court or there's proven deprivation, proven neglect, maybe sexual abuse. And then we're talking about if they're bonded with their parents or not bonded with their parents is a factor, which seems ludicrous to me because I've seen sexual abuse cases where both parties will say they're bonded.
Right.
It's really subjective, and I think that we're looking at that as a line in there is really scary to me, that we're even considering that. I understand a bond, but we're not talking about average parents that are bonded. And nowhere in this discussion have I heard anything about the option of open adoption for those parents instead of a TPR. I mean, TPR can happen, open adoption can happen, and then you've got the best of both worlds where they're being monitored, maybe supervised visits with that parent, whatever situation they were in, by their adoptive parents. I don't think anybody discusses open adoption
Right.
in these cases.
So your two issues here. Number one, obviously, the point that the bond shouldn't matter when the parent has. I love you so much I'm going to sexually abuse you. I mean, that's obviously. And number two, what about the issue of open adoption and supervised visitation? I think on the first issue, what I think is that the court wants us to consider the bond and, let me put it this way, it's not so much they're bonded, so let's not sever the relationship. It's more this. Let us balance the bond versus the consequences to the child of continuing that bond. So there were a couple of cases that have been come down in the last couple of years where the Court of Appeals felt the juvenile court didn't even consider the bond. In fact, in one of them, the court said the child and the parent are not bonded at all. But yet there was evidence in the record that from the guardian ad litem and from the social worker that, oh yeah, the child loves the parent. So it's more this. When the evidence demonstrates that the parent, and I'm just going to use a very loose and probably inappropriate term, okay? Sorry and worthless. Okay? Now, I think that a lot of you know sorry and worthless parents who still have their parental rights. Okay? I think what the court is telling us is this. The purpose of the TPR hearing is not to declare the parent sorry and worthless only. It is to go further and say, is the parent so sorry and worthless that a continuing relationship of any type between that parent and that child is going to harm that child? And there are a couple of ways I think the various evidence indicates that could happen. One is, of course, the physical, sexual, active abuse type of situation in which continued exposure to the parent would actually endanger the child's moral, emotional, physical, or social development. Okay? And the other type of harm, perhaps, is that where the child needs love and affection and an attachment that parent is so sorry and worthless that they can't give, and not having that attachment is really going to harm this child in the long term. See what I'm saying? It's just that the court is just telling us if you show the child is deprived, you can remove the parent from the child all day long. But if you want to sever that bond so that child can be adopted, please show us why that severance is necessary. And I'm sorry, on your other issue, the other, of course, yes, could you do an open adoption? But of course, I think in those situations, you're likely not dealing with a contested TPR. You're probably looking at something that has been the result of permanency mediation or a mediation process where the foster parent or the potential adoptive parent and the biological parent have gotten together and said, the parent has come to the conclusion, this child needs a family. I'm never going to be able to provide that. Y'all can, but I really would like for this child to know who I am. So that's a different situation, I think.
That discussion rarely happens, though, if the foster parents don't understand open adoption. The judge never introduces it, or DFACS never discusses it.
And I think Jim may be able to speak to this as well, but I think that is something that I don't think we've gotten that. Right now we have a statute that allows if you're 14 or over. I don't think we've gotten a handle on the concept of real open adoption right now. Of course, what we have now is merely a promise. Yeah.
Well, I think, Tom, to your point, and then you said it, either the judge has to embrace it and suggest that it be part of the process, or DFACS has to, and DFACS has run away from it.
Right.
They don't want to touch it.
That's right.
So they keep the parties apart when that could resolve and eliminate the contested TPR.
Yeah.
Because it could be mediated to work open adoption and a post-adoption contact agreement could resolve and put a forever family together and not exclude the birth family, an appropriate birth parent who should be in contact, whose contact would not be detrimental to the child. And
so just to repeat what you're saying, if DFACS has kind of run away from the whole open adoption stuff. I think if we're going to have it, it's going to have to be us attorneys and judges who are bringing it up. Also, we have had in our cold case project, which many of you are familiar with, we're working with kids who have been stuck in foster care for long periods of time without any kind of permanency. We have been successful in helping some achieve permanency with permanency mediation. Okay, so we actually have some folks who have been skilled in knowing permanency options, and I guess skilled in mediation, who can sit down with the parent and the potential adoptive or potential permanent family and say, what's this going to look like? And say to the child, especially if they're 16, and you have lots of 16-year-olds who say, well, I don't want to be adopted because I'm going to go home and see mama. But they really want a forever family. And so you sit down with them too and you say, well, what do you really, forget the name. What do you want? So, yes.
I'll say, and just from the counties that I represent, I can't say that we run away from them. I don't think policy-wise I have gotten to that point yet, but it depends on the parent. I mean, some parents, I wouldn't want to have my address, so, it depends. We have had a lot more. I've noticed foster parents, I don't know if they're having a discussion with foster parents lately, but I've been noticing foster parents, had a TPR the other day where, had discussions with mom about, they made their own little, it's not legal, but their own little agreement. So I don't think we're necessarily shying away from those, but so, it is what it is. With some people with TPRs, there's a reason.
Well, and I made my policy statement during the legislature. DFACS didn't want to have anything to do with it because they didn't want to have any responsibility in it. So that's what
So, and I think
I'm saying, that
to-
individual SAGs, parents, attorneys, child
right.
attorneys should
To-
bring this up, I think.
to bring y'all together, it's not a policy of defects, but certainly individual SAGs and others in the system, and maybe individual defect workers and stuff are working on it. Yes, ma'am?
One of the problems with defects signing off on it is that, the nature of the case is adversary. And if you spend, 9 months talking about this is a bad person, this is a bad parent, they haven't done this, they haven't done that, at TPR time, it's difficult for them to switch their position and say, okay, now we want, you to work with the parent, to get stuff established. The other thing I want to say about open adoption, because I have had some cases in which, even before the statute was enacted, the foster parents had made an attempt to keep the family in. At a certain point, it becomes, they're not your real family. And so setting the parameters of the interaction between the two, it puts the kids in a position sometimes where they get real stressed because they've got their new family here, and they're trying to make contact with their sisters and their brothers and all this stuff, and they're saying, well, you don't have to do that because this is not your real family. So it's a good idea, but, again, how do you set the parameters of the interaction with the kids? And when I talk to people about it, I say, the relatives, I say, you have to learn to respect the adopted family. And if you're not willing to do that, then you shouldn't open this up. So it sounds good, but it's difficult sometimes to strike that balance.
Yes, ma'am.
If a juvenile court judge has ruled twice against a parent, terminated her rights twice, and then she appealed, and the appellate court judge finds that there was something wrong with that judge overseeing that case twice, is that wrong?
So the question is, if a juvenile court judge has ruled for TPR twice, and then the appellate court found there was something wrong with that.
That she should not have handled that case twice. So the child was taken from a pre-adopted home that she had been in for almost a year and given back to the mom who didn't want her. Then the mom took the child and gave the child to some distant relatives.
I need to look at that one. So tell me about that case afterwards. Back in the back.
So one of my concerns in seeing the current cases coming out of the Court of Appeals is how they're balancing 15 out of 22 months.
Right.
And how there's that federal statute that says 15 out of 22 months, you have to have a compelling reason why you're not filing TPR.
Right.
And the Court of Appeals is basically saying, give them some more time. Give them some more time.
And
there's not enough harm there.
I want to repeat what you said because I think it's an interesting comment. So how's the Court of Appeals balancing, or how are we balancing all of this? The whole idea that the feds and the state now says we have to, you better file for TPR if the child's been in care for 15 out of 22 months if you don't have a compelling reason. There's a court, the Supreme Court, I believe it was in Illinois. And forgive me if I'm wrong, but I know it was one of the appellate Supreme Courts in either Michigan or Illinois, said that that particular part of their state code was unconstitutional because they decided that it was too much of a constraint on the family's right to be together. I don't really see our court ever taking a firm stance on that. I think that our court is always going to be focused on, not on necessarily federal concepts or social work concepts of how quickly permanence should be done, but on the two basic and often conflicting issues, which is, number one, the fundamental right to family integrity versus the fundamental right and duty of the state to protect children who are in danger. And I think it's those two I mean, honestly, I just don't think I think we in the juvenile court world get into the details of what these things mean. I think that appellate courts often want to deal with some very basic fundamental clashes. And so that's what they're looking at, and what they're saying is, okay, if we're balancing these two things, was there due process involved? Was there sufficient due process that a court could balance it properly? And if that due process was present, where are we? Who wins? That may be a really lame answer, but that's the best I can do. Anybody else? Yes.
Tom, one point to me, Judge Dillard and his death penalty point of view, I think needs to be contrasted. That's from the parent's point of view. But I would submit that severing the parental tie could be the gift of life to a child. And when you only look at it one way, you only see one thing. If I only have a hammer, everything looks like a nail. And I think the court has shifted its balance too much to the death penalty view, and the child is lost. It is the juvenile court, it's not the parent court.
Right. And I hope that came up on the thing well, because I think that's well said. And yes, ma'am. Oh yeah, you had an interesting thing.
We have, we're a foster care agency, and we do a lot of foster to adopt, we do a lot of family reunification. We support permanency, however, it happens for the child, so we don't want them to linger in foster care. But when we have cases that TPR, and then we're told by DFACS that they've been appealed, and they're in the Court of Appeals, and it's going on 2 years.
Right. Okay. Let me point that, because I meant to bring that up earlier, because you said it to me at the break. So, what do you do with these cases when you're sort of on the receiving end, kind of a case almost, and you hear the DFACS or somebody says, well, this case has been in the Court of Appeals and it's been like 2 years. This is what, when I was talking about the transcript issue, the primary reason for delay in disposing of these cases on appeal is the lack of a transcript. Now, how many of y'all do some criminal representation? We all know that it takes like forever to get a criminal transcript. And I think, quite frankly, that we have a lot of work to do with making the court reporters understand that these things, this is not just some case. This is a child's life, and this transcript needs to be done like that. But I don't know that we have, except for, I think right now it's on the attorneys, whether it's the state attorneys, the parent attorney, the child attorney, to push for getting that transcript as soon as possible. And I say this, I have not always been, I'm not without sin on that issue too. Because you think, oh yeah, the transcript, I kind of forgot about the transcript. And suddenly 30 days have passed and it's like, oh, I better do something about that. So I think one of the things we need to think about right off the top of our heads, whenever we do an appeal, is how quickly can we get this transcript? And I've got an obligation to push for getting that transcript now.
But how can you just call the Court of Appeals and find
No, you call the court reporter. Oh, the Court of Appeals. If you call the Court of Appeals about the pendency of a case, you can find out.
What's holding it up?
No, you can't find out what's holding it up. But what I would ask the attorneys for whoever is involved is, where is the transcript? Okay. Now, all that aside, my favorite expression, where are we going and why am I in this handbasket? So we are not, in fact, all going to hell in a handbasket. Everything, I want to go back to this basic point. Everything old is new again. We have the same issues that come up time and time again. And as Jim said, one day it's all about the parental death penalty. The next day it may all be about child safety. I think wherever we are in the system, our job, and really, we can take one side or the other. We can be on the child side or the parent side or whatnot. But our job really is to try to make the system work, understanding always that we need to protect children and we need to make sure they have permanence and safety and stability. And we also have to have a system that parents will respect because it treats them fairly. And that's kind of what it all boils down to. Yes, ma'am. Last comment.
I'm not an attorney, but for the benefit...
But you should be.
The JM program here, but for young people who may be, or young adults who may watch this, so in part asking this question for to capture this that they may have, but if it is applicable in this context, can you comment briefly on any implications for the piece of the new code where young people can request a reversal upon, adulthood?
On TPR, yeah. The law now allows the reinstatement of parental rights in certain cases, and that might be especially helpful for children who, unfortunately, have been left as legal orphans. We have way too many situations where termination of parental rights was carried out perhaps with the expectation that a child would be adopted, and it just never happened. And these youth, especially, everybody needs a family. Okay, if they don't, they may want to. First of all, they ought to read the latest edition of Vox, because that has a good primer for youth rights, and talk to Empowerment, and because that's our great youth organization for kids aging out of foster care. But you can also reinstate parental rights in Georgia now if you happen to get back with your family. Thank you all so much. It's been a pleasure.
I just wanted to remind you guys to return your evaluations, and thank you again to Judge Rawlings.
Say good things.